Now, whether they figured she was fired because maybe some of the words she was using maybe made them believe she was fired, but that's how I got that information. So my sources are the lawyers, of course. They're usually a really good source. All right, so before I pull Randy on, let me check Rumble one more time to see if maybe we can get this thing up. It's not looking good, though, folks. Rumble's not looking good. So, Padge, if you can put a chat in a Rumble, because it is really slow, tell people to go to Facebook, YouTube, and other, and let them know I'll rebroadcast on Rumble a little bit later today when it's up. Okay? Make sure you let them know that Rumble will get the broadcast. All right, folks. There you go. There's your start. And I really want to get to Randy, because Randy is kicking some butt. If you don't know who Randy Hilliard is, he's an MP. He was an MPP, a Conservative MPP from Ontario. They eventually kicked him out because he stood up. We'll get into quickly because we want to get to the letter of why he got kicked out, became an independent MPP, and then finished his term that way. He found himself in some trouble trying to do his work, going to work. He found himself in some trouble, and he's been charged, and we're going to go over some of that today. So without further ado, hello, Mr. Randy Hilliard. How are you today?
Good morning, Jason, and everyone watching and tuning in wherever you may be.
I love you.
Yeah, I would have paraphrased your introduction with saying it like this: "Never trust a lawyer." Is what I would have said. Languages and facts are not always the same in the legal world as they are in the real world. So, we've all to learn that. So,
well, Randy, here's the problem. Like, we learned this yesterday because Chris Carpenter posted it on Facebook. She's received $550,000 in fees. So she's been paid just over $500,000. And according to Chris Carpenter, I haven't verified this. He's the only source for this information. Tony Olenek, the man in remand, asked for the statement of accounts, a breakdown of the $550,000. That caused a problem. Mm-hmm. She quit.
Yeah.
So that's all I have right now. Like, to me, that's not a legitimate reason for the lawyer to quit, and I can't believe the court would accept that as a resignation. So there might be more to it than that, but that's where we're at right now. It looks like he was looking into the accounting, and then she quit. I really want to validate that because that sounds peculiar to me.
Well, okay.
Back to you, though. Back to you, Randy. So thank you for joining us from Scuttlebutt Lodge. I recognize that place. I've been there.
It was a beautiful morning. Got out nice and early. Took a walk around the camp and let the chickens out. And it's a beautiful morning. So, but now I guess we'll get into the meat of the matter. And
yes, sir.
Just how ugly and monstrous this legal machine has become, and the evidence that we can say that. I guess for some people, I'll just say, I was and am, as far as I know, the only elected member of any provincial legislature or parliament in Canada to be criminally charged for advocating for freedom.
Wow.
And that happened on March 28th, 2022. I was a sitting member of the Ontario legislature representing Lanark, Frontenac, and Kingston. I had been a member at that time for 15 years. And shortly after I announced I was not going to seek re-election, the Ottawa Police Service began an investigation into my actions in Ottawa in January and February of 2022. And we all know what happened in Ottawa at that period of time. I am prohibited from speaking or using terminology, but I would like to, but I might.
Yes, let's not. And we don't need to complicate your life any further. So there was an event in Ottawa that you went to, and you got yourself a couple tickets out of it.
I've got 9 criminal charges, and the Crown is seeking 3.5 years of incarceration for me for charges of mischief and trumped up BS charges of assault and obstruction. And I think a lot of people may have watched that video of me on Parliament Hill moving a barricade, a temporary steel portable barricade. I moved it away from the from the crowd and from the peace officers. The Crown at my bail condition characterized and misled the judge and said that I threw this steel barricade at the police. A total fabrication. Anyway,
sure, it looked like you just moved it. There's no
Yeah.
throwing and nothing like that.
So, and I had been kicked out of the Conservative caucus previous, because I had been exposing the political corruption from the parties and the influence peddling and the money and the bribery that's going on with the lobbyists in the Ontario legislature. So Doug Ford didn't like me doing that. His key advisors and influential people didn't like me exposing that, selling legislation for money. So I got kicked out of the caucus and sat as an independent. So that takes us up to today, on November 17th, after spending tens and tens and tens of thousands of dollars on a lawyer. I fired.
Parted ways.
My lawyer and I parted ways. Let's put it that way. We parted ways, and I chose to self-represent. And it's, and I'll maybe just say this, Jason. It was obvious to me that giving money to lawyers is indirectly just growing this legal monster in this legal machine. This monster that is attacking freedom-loving Canadians, law-abiding, freedom-loving Canadians. Every time these lawyers are sucking up all kinds of money defending people like myself, and is actually growing the machine that is attacking us. And I said, I'm not going to feed this machine any longer. I'm not going to feed this monster. And I don't have to play by the rules of other lawyers. I'm not an officer of the court, so I have no obligation beyond my charter-protected rights and freedoms. So that's what I've decided to do. And lo and behold, I've had 3 appearances now in court representing myself. The Crown, the deviousness, the skullduggery of these buggers, right, is they are trying to deflect their own politically charged and motivated actions and characterize it as I am being obstructionist. So this week,
That's bold, by the way, for him to say that.
Say that again?
That's bold of him to say that, but please continue.
Yeah. Well, so this week, I sent a letter to the regional senior judge, Judge Macleod.
I'll pull it up.
Yeah, pull it up. It'll be published on my websites later today. And in that letter, I dispel the falsehoods and the mischaracterization of the Crown in regards to this case, and point out a number of very glaring and obvious mistakes by the Crown. And maybe I'll just go over a couple little items as a recap. The Crown and the judge have not scheduled adequate time for the defense in trial. Both the Crown and the defense identified 29 days of trial. The judge only scheduled 20 days,
right,
over my objections, because obviously, if that happens, my defense will be interrupted, but the Crown will have an uninterrupted attack on me.
Correct.
So, and I also point this out, that the schedule that they have, which is now in February of 2025, exceeds and goes well beyond the time frame identified in Jordan
Right.
that for a speedy access to justice. But here's a couple of other things you'll see in the paragraph above. There's some language that most people won't realize, but it's the appointment of an amicus and counsel. And right at the moment, I'm fighting 2 Crown attorneys, and the judge is a former Crown attorney.
Mm-hmm.
And the Crown now wants to have 2 more lawyers appointed as amicus and as what's called a 486 lawyer. And they want to do this without my input, without my influence, and without my concurrence. And, we very well could have 2 more crowns. If 3 wasn't bad enough, they want to stack the deck even more. So I've indicated to the senior judge that any additional judges appointed, any additional lawyers appointed must come from a defense background. And just to clear this up, just for a 486 lawyer, is the Crown is suggesting that these 2 young, burly parliamentary precinct police officers might be intimidated if I cross-examine them.
Right.
Trial, and they might suffer some trauma if this senior citizen named Randy Hillier cross-examines them in trial. So they want to take away my ability to cross-examine my accusers and potentially appoint a lawyer that I don't agree with.
Right.
So these are just little legal wranglings that but important ones, because they don't provide access to justice. They don't provide a fair trial, but stacks the deck against the accused. So there's a couple of items in there, but there's a litany. For example, I am a senior citizen now. I feel good. I feel healthy. I work a lot, but with age, my hearing, I have difficulty hearing after a lifetime of working around machinery and equipment as an electrician and in the bush. I've got poor hearing, and I asked the judge to accommodate this disability by allowing me to record the audio or to have a friend in the court assist me. Both those very reasonable accommodations, which have been, which are fairly standard and agreeable in most courts, in most cases.
And it's normal for a reporter to do exactly this for their note taking, for their reporting. So reporters would be allowed to do this.
Yeah, but they refuse to allow me that. And I guess the greatest one, the other one that is, the Crown is seeking to prevent any publication of any information on this trial in the pretrial process. And I'll characterize this to your audience. Everybody in Canada has been subjected to a relentless tsunami of falsehoods over COVID for the last 4 years. And of course, those were the things that caused those events in Ottawa to happen: the mandates, the vaccine mandates, the mask mandates, the curfews, the lack of mobility. That's what generated all these people to come to Ottawa back in January and February of 2022. So all those, which we now know, the jab was not safe nor effective. The masks were not effective. The isolation was not effective. And there is overwhelming evidence that the pandemic was a con job by everyone. Most everyone was conned by Pfizer, Moderna, our governments, big tech, powers that be. And the Crown has suggested that if I talk about this pretrial, then I will taint the jury pool. But
are you planning a jury?
Oh, yes. Yeah, definitely.
Okay.
I will not allow my fate to be in the hands of a single judge. I have a right to a jury trial, and that's what will.
Okay.
But here you go. This overwhelming propaganda machine for the last 4 years that continues today, that is confusing the jury pool, confusing the public, that is providing incorrect and false information to people, that's allowed to continue. But anybody who opposes it, well, we have to put a muzzle and a gag and try to put a publication ban on my defense. So I'm going to fight these things. I'm going to fight them hard. And I have no doubt that we will kill this monster called the legal system at the end of the day. Expose that it is morally bankrupt, that it is in a financial conflict of interest, that it is politically charged and motivated. And I've said this in the past, I'll say it again. The law, because I was a legislator, I crafted and debated and voted on law. The law is intended, it's designed to be a shield against tyranny, a shield against authoritarianism. It is there to safeguard and protect the freedoms, the property, the well-being of society, of individuals within society. And now we see that the law is being used not as a shield, but as a sword to skewer and to slay and take away and deprive people's freedoms, people's well-being, their prosperity. And I'm going to turn that law back into what it ought to be, and that is a shield that protects people from these petty little tyrants and abusers, like what we're seeing in Coutts, which we're seeing in Ottawa, where we're seeing so many people being subjected to these petty little abusive tyrants. I've dealt with people like that in the past, in political parties and in government, and I don't mind taking on these buggers in the courts either.
Correct. And Randy, I'm very proud of you, because what you're doing is you're taking on a pretty big beast here for sure. And if there's one thing that can come out of your endeavor, and this is what I'm really paying close attention to, because I think you might be the groundbreaker for this, is to attack publication bans. They're actually I call them truth bans, because they don't ban publication. They only ban publication of the truth. So you could publicize and publish the falsehoods all day long. They'll let you do that. So malinformation all day long. They're happy that you do that. But the moment you publish the truth, then you're in trouble. You're in trouble. So it's not a publication ban, because you can publish lies all day long. It's a truth ban. So I'm very, very curious on how you're going to be able to do that. You maybe challenge it. They may have to come at you. They may do a contempt of court against you that you eventually win something. But October 2022 or 2023, so just a couple months ago, the Supreme Court has upheld a definition of the pretrial bans for publication and broadened the scope of it way beyond what his intent was. So I absolutely think this needs to be challenged. If anything comes out of this, your 9 charges, God bless you for fighting those. But the publication ban, I think that's one of the biggest problems with the justice system recently, is because that's a truth ban. Full stop.
Well,
and we see this all over Coots. Like, this happens everywhere in Alberta. It's frustrating.
Yeah. No, listen, we know this intuitively. We know this historically. This is bred into us. We know this. The only people that want to hide their actions are those people who are engaged in wrongdoing or engaged in actions and behaviors that they would be ashamed of if they were known. That's why the adage in due process, and it's a hallmark, is for justice to be done, it must also be seen to be done. So
correct.
The publication bans are to be in those very specific cases where a minor child might be involved and you want to protect their identity, or the victim of a sexual abuse or assault, or in the case of national security, where secrets to the defense of the country may be exposed. So that's the groundwork. Everything else must be public. And here we are, mischief charges, trumped up and BS, assault charges now are too dangerous to allow the public to see. But I think there's a couple things that I want to share with the audience, because this is what I'll be sharing with the Crown as well. And I just want to read a little bit. It's the Public Prosecution Service of Canada is the governing body. It is the legislation that authorizes the Crown attorneys to act, and it also describes and prescribes how they must act. So let me just read. This is you can get this on the website under the federal government Public Prosecution Service of Canada. And it states, this is 2.2, duties and responsibilities. Crown Counsel's primary interest is not to secure a conviction. Rather, it is to pursue justice. In doing so, Crown Counsel represents the public's interest.
Mm-hmm.
They are not lawyers for the police, the victims, or the accused. The Supreme Court of Canada articulated that the Crown Counsel's role in the context of a criminal prosecution in its landmark decision, Boucher, right? But it goes on. It cannot be overemphasized that the purpose of criminal prosecution is not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence relevant to what is alleged as a crime. Now, our Crowns have forgotten the manual. They have forgotten, and they now believe that they are instruments of the state to find convictions everywhere. I'm going to remind those Crowns and the judge just what the purpose, what their obligations are. And because there's one other really powerful item that the Crown and the judges, I believe, have forgotten or disregarded, and that is the solicitor's oath. Every lawyer in Ontario, in every province, but I'm going to speak about Ontario here. So every judge, every Crown attorney has sworn an oath when they became licensed at the bar, right? And I'll just read a little bit from that oath. It says, I shall neglect no one's interest and shall faithfully serve and diligently represent the best interests of my clients. I shall not pervert the law to favor or prejudice anyone, but in all things I shall conduct myself honestly and with integrity and civility. I shall champion the rule of law and safeguard the rights and freedoms of all persons. Every lawyer in Canada has taken such an oath. Every judge has. And I think it's time that we bloody well remind them that their role, their responsibility is to safeguard the rights and freedoms of individuals, not just to attack them, persecute them, and try to ruin them financially in the process.
Look, Rule 2.2, I think, is going to become very important for people who want accountability and go after the Crown after they've done stuff like this. I have a gentleman in Windsor that was on the show just the other day, and he had the exact same thing. Okay, false charges. He was vindicated by a drone video that showed that he was where he was supposed to be, not where the police said he was. So he was vindicated. However, during his proceedings, the Crown was very vocal, and it's on the record that the entire reason for pursuing charges against him was to set an example for others. Yeah. So that's absolutely pursuing a conviction, not pursuing what's right for the public, and certainly was not right for him because he actually didn't do anything wrong. But the Crown was willing to sacrifice this gentleman. Sacrifice. I'm pretty sure nowhere in the prosecution statute does it say you're allowed to sacrifice people, but that's what they were doing, sacrificing him to the public to show everybody else what will happen to you if you protest against this government. Now, let's keep in mind, even that message to the public is a miscarriage of justice because he didn't actually do anything wrong. So we're not learning a lesson from his mistake because he didn't do a mistake. So I think Rule 2.2 should be at the heart of a lot of lawsuits against the Crown because that's exactly what they're vitiating.
We know that this was the purpose of all these charges in Ottawa and elsewhere.
Correct.
There was a couple things. The first one, those events in Ottawa embarrassed the government. They embarrassed their government because all these significant numbers of Canadians had now rejected the narrative of fear. All these Canadians understood that they were being conned, and they came to Ottawa to oppose the con job by our governments. So that was an embarrassing time, and politicians hate to be embarrassed. Trust me, that's the worst thing for a politician. So they had to create a narrative that deflected the responsibilities and that attacked the people who were embarrassing them. And that's why they came up with this whole narrative of an insurrection, overthrowing democracy, a bunch of yahoos and racists and misogynists and blah, 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 blah. But that wasn't sticking because everything was so peaceful and so exuberant and so joyful. So they had to find some villains. They manufactured some villains in Coots. They manufactured some villains in Ottawa to justify that false narrative of the overthrow of democracy. And then one other thing that was important in this was to intimidate the rest of Canadians. Go after a few people, some higher profile people, and make examples of them and try to intimidate Canadians from having a voice, having a backbone, and being out opposing this tyranny and this injustice. And, listen, government is a big apparatus. The state is a big apparatus. But, I always understood as a young boy growing up, was the bigger they are, the harder they fall. And that's what we have to do is they're big, but they're not that big. And they're big, but they can still be taken down. And their lies and their falsehoods will take them down.
Yeah, and they were effective because there's two things that they really attacked, and it was effective even to this day, Randy. And we're still trying to get out of the gutter on this one. Fundraising and leadership. So fundraising, they attacked it by shutting down the Give Send Go, attacking people who donated, even a police officer for $50. So they made Canadians very wary about fundraising. And then leadership. because they went after Tamara and Chris and you and others, it made it difficult for people to become and identify themselves as leaders. So we saw this happen with that attempt to do another convoy where nobody's a leader. Like they're actively trying to make sure that nobody is identifying as a leader. And that's why it's going to be difficult to mount another, I don't say attack, but another protest, because who wants to be Chris Barber and Tamara Litch next time around? Who wants to be pulled over across the country on warrants and put into jail? And who wants to go through that? Well, nobody. So they made an example of leaders. And again, they didn't do anything wrong. So I think, eventually we're going to get to that. But they also went after fundraising, which made it really difficult to go ahead and mount a resistance of some sort. So it's still working. But Randy, I think what you're doing here is going to help open that door to leaders again, because you're going to ideally fix this whole mischief stuff and show people that you can fight 9 criminal charges, even self-represented. Are you using a charter for this? Are you using a charter in any way for this?
Not at the present time, but of course the charter, like the Jordan ruling, is a derivative of our charter. There's a number of things in the charter that potentially can be utilized. But right now, I want to have my day in court. Like I truly do. I want to have my day in court, and I want to expose the lies and the con job that the Canadian public were exposed to. I want to expose this, this agenda of fear in falsehoods. And I know this. I have the disclosure now, or I have some of it, the disclosure now. This is approaching 2 years, and it was just this week that I got a video of my interview with the Ottawa Police that took place on March 28th, 2022. So nearly 2 years just to get a video. There's still about another dozen items outstanding that the police haven't provided to me. But one of the things that they have provided is I now know that the investigation into me was launched and initiated by an elected Ottawa politician. Right? That is what I know.
They're supposed to direct the police.
It was an elected individual in Ottawa, senior person, called up and sent a letter to the chief of police and others about investigating my actions.
Okay,
right?
That's not supposed to happen.
So that happened on, and I just to give everybody some context here as well. This great assault on Parliament Hill that I apparently was engaged in with the steel barricade, and go on my YouTube channel. It's 24 seconds long. You can watch. That is the entirety of the police case and evidence. And that happened on January 29th. They didn't begin the investigation into my actions until after I announced I was no longer going to seek elected office. They weren't going to touch me if I remained in elected office.
Oh, wow. Okay. I can see the dots coming together here.
Yeah. But as soon as I announced that triggered my political opponents in political opposition in Ottawa to use the law as a sword against me. And these people, the Crown and the police, also groveling for recognition by the political state, did their bidding and began the investigation into me.
Wow. Well, let's take a look at your weapon here with the great assault on Parliament Hill. I pulled up the video here. So, folks, if you have children, maybe now's the time to remove them from the room because this is a great assault on Parliament Hill. So let's go ahead. And if you're pregnant and all that kind of stuff, take a deep breath. This is vicious.
Let's go.
Oh, wow.
Go!
All right. First of all, I love hearing that sound. I can't.
Recordings.
I never get tired of hearing those horns. But second, I saw what happened was you moved the fence a little bit, and then you moved it maybe 2 or 3 feet more,
Yeah.
and then you saw a couple officers walk off from below on the screen towards you.
Yeah.
So are those the officers that feel like you threw that fence at them? Are those the ones that are claiming that?
Listen, the officers never said that. That was
Okay.
the Crown prosecutor, Tim Wightman, who described that event as me throwing a steel barricade at the police. And that was what they used to justify all the significant bail conditions on me, my prohibition from attending Ottawa, which all remain. The prohibition on me speaking with material witnesses, my prohibition on speaking on various subjects, was all derived from the Crown's fabrication to the bail judge that I threw that barricade and that I was a violent, uncontrollable individual.
Wow. Wow. Okay, Randy. So I'm disturbed. So the two officers we saw come off are those the ones that are worried about you cross-examining them, and this is why they're looking at that rule. So those officers, according to the Crown, they're going to be intimidated by you if you ask them questions in a cross,
and that they would suffer, PTSD or something if I was to cross-examine them. The sun is coming up. I'm just going to close the curtain here a little bit.
No problem. And what we'll do is we'll introduce Amanda too, because Amanda has popped in and we got to see her. Amanda, thanks for making time for us. You're a bit of a star now. You're all over the place. You're on Viva. You're on shows like crazy now, which is great.
Because of you.
Sure. No, I think it's merely because of you. I identified that you really should be in front of the camera. I'm just an encourager, and hopefully it goes well for you. I think you're doing a great job. Now, the reason why you're here is not because you're an awesome person. We just like to bring awesome people on. You're here because you're actually assisting. First, you're covering the Randy situation. So you're covering the court matter itself. And you're also trying to help him because like a friend of the court, like somebody that can assist Randy for note taking, because it's not that he's not doing a good job. He's doing a great job. But he does have a hearing issue and he should be able to capture notes and be able to do some of that. So you've been trying to assist with that. So go ahead.
And it's not even like even just a hearing for Randy, right? When he's busy, he has a question to ask and then they're answering, he needs to, write it down, and he needs to keep the pretrial moving and
keep the flow.
It would be kind of odd to go, okay, just check, Your Honor, and then, take some notes and then keep going. And we do that. We do ask for a moment, and we do. But in terms of Randy, even if he could hear perfectly, the request is there. And in my opinion, it's not absurd to just have someone take notes. I mean, the media can record, like you were saying.
Mm-hmm.
So if the media can record, why can't Randy record?
No. And what's interesting about that, Amanda, and thanks for joining, but, the Crown has two Crown attorneys in there prosecuting me. One is making the arguments. The other one is taking the notes and providing the additional material. So, like that is a normal practice. It was the same thing. The courtroom is similar to the committee hearings at the legislature, where you have a chair in the courts. Of course, it's a judge, but you have a chair to keep the matter moving and to rule on objections or points of order or what have you. And then you have witnesses appearing in the committee hearings, and the elected members question them, and we have our staff in that committee room as well to continue to take notes and to provide material to those elected members who are questioning the delegates or deputants to a committee. So this is this is a normal practice. It's difficult to have a fair trial if you're not permitted to engage with at least the similar opportunities as the other side. So okay, maybe if they don't want me to have somebody else, you kick out the other Crown out of there too, and let's go one-on-one, and let's see who wins.
No, absolutely. Oh, sorry. Go ahead, Menda.
No, that's okay. That's okay. I was just going to say, and that's just it, right? There's just an imbalance. And if Randy is struggling with all the clout and, attention that he can garner to support him, if he's having a hard time, I can't even imagine, the gentleman that you spoke to last week, like you were saying in Windsor, like these people are fighting these battles alone, who don't have the assistance of people pumping their information on social media and driving support, because it does help to have a little bit of support behind you, right? Whether it's financial, whether it's you can do it, the rah, like keep the good fight, because we all need that. And if I'm so grateful that Randy is doing this. I'm so grateful that Randy reached out to me initially to do when he first let go of David Amber. Because I want to see this unfold. I want to see Randy expose everything. And I think that's the goal more than anything. He can Jordan out if he wants to, right, Randy? I think it's going to be great that you're going to start exposing what Jason and I wouldn't have been able to expose, for example. Like, he was an officer of the court. I may be an officer if I choose to. And we're both not,
Look, and one more thing there, Amanda. I'm a conservative, so I hate making a statement. Can you move to the left a little bit?
Oh, there we go.
Just a little bit to the left. Thank you very much. Randy, I do know, though, that you are a criminal. I got proof. You have bail conditions that don't allow you to be downtown Ottawa without counsel, and you don't have counsel. So you have at least 3 breaches there. What's going on with that? Because that has to be a condition that's got to be removed. Or clarified that you can go down there, because technically, according to your letter, you just admitted to a criminal offense, a bail breach. What are you expecting them to do about that?
Well, on November 17th, I identified that to the judge and to the Crown. I said, I am now representing myself. I'm in downtown Ottawa, in the courthouse, in breach of my bail conditions. I think it's time we revisit these bail conditions. And that's really clearly the irony here should be obvious to everyone. I'm summoned to court, but if I attend, I'm breaching my bail conditions. If I don't attend, I'm also breaching and in contempt of the court. So you're damned if you do and damned if you don't. So it's been a month now. The Crown has yet to issue the variations on the bail. And I've said to the Crown, like, keep the surety in place. There's a $35,000 bond in place for me keeping of the peace. Keep that in place. But you cannot frustrate my ability to defend myself. You cannot prevent me from speaking with material witnesses. And that's what the bail conditions do. There's a great number of people that I'm not allowed to speak with who were and are witnesses to my actions in Ottawa. And I'm also prevented from going to the crime scene and taking pictures, collecting evidence, taking measurements of the great assault, or the scene of the great assault, which again is violating my ability to defend myself. And I point that out in my letter to the senior judge once again. Like, this cannot be permitted to stand. Like, you cannot guarantee me the right to defend myself and then put these shackles on my legs and my feet and my hands and put a gag and a muzzle and a bag over my head to defend myself in the court. They're setting themselves up. People should be able to see, and this Crown should be able to see what is going to happen here if they continue to act in an obstructionist fashion in a manner that is prejudicial to my fair hearing and defense. It shouldn't take a rocket scientist to see, and they're going to have to cough it up. They're going to have to cough things up, or else, like it really, they are running a big risk, and it's all because they don't want. Like even this element, they figure that they can financially ruin me and make me plead out. So one of the consequences of not being allowed to record things is I have to order the transcripts for every hearing.
That's right.
That takes time and significant amount of money. I have to apply to the courts to get the typed out transcripts from every event because I can't record it. And I need those actual statements to be able to then demonstrate to the court how the Crown is trying to put the screws to me, not to seek justice, just trying to skewer me and ruin me. So they've got another thought coming. I'm not going to go down very easily.
Yeah. And this is a bit of an entrapment trick, by the way, just so people understand. This is how innocent people can end up becoming criminals according to the justice system. So you're an innocent person, you get charged with a crime, you agree to bail conditions so you don't sit in jail while you're waiting for your trial, because again, you're innocent, you don't want to be sitting there. So you agree to some bail conditions. And I saw a comment, does Crown have a contract with Randy? They do. It's a bail conditions. It's a contract. So they put you under this bail conditions. And then sometimes they're onerous and you accidentally, like Tamara taking a picture with her counsel in the room, but not in the picture. That was enough to revoke her bail. And then you actually can be charged for breach of bail conditions. And that's a legitimate charge.
Yeah.
The person who had nothing wrong becomes a criminal according to the legal system.
Yeah, that's exactly what it is. It is, and we've seen this with Tamara, and it's been one of the reasons why I was hesitant to go to public events, because I've had people reach out or attempt to reach out to me who are prohibited, that I'm prohibited to speak with. So I'd say, I'm not going to communicate. I'm not going to get caught in this trap. And it's also limited my ability for public exposure going places, because I might inadvertently run into somebody at some event that I'm, and somebody take a picture, put it on social media, and back in the crowbar in. So
correct.
So now I've put it on the record. It's right under the nose and in the face of the Crown that their bail conditions are a farce. And I dare them, put me in jail for a breach on February 12th when I come back to Ottawa to go to court. Do it. I'll be happy to stand in front of the bail judge and said, well, yeah, I breached the condition, but I was also summoned by this court to be here. So you tell me what to do then. So, they don't want to have their contradiction and their irony and their hypocrisy exposed. So they're too fearful to do that at the present time.
Yeah, and you've been really good at that, because even on your first interview here, we had to go through certain topics we couldn't touch because they're part of your bail conditions. And getting out of your letter, so I read it very carefully, you're attempting to modify these bail conditions with the Crown. You've wrote to them, you've asked them for consent on it, because that's one way to get it modified. But it looks like they're going to require you to do a motion, so actually take up court resources to actually address this issue. That's looking like that's the direction it's headed. Can you correct me on that? Are you getting cooperation from the Crown, or are you going to have to go through the court for this?
No, like the Crown has refused to communicate with me outside of the court. And again, this is not the way, typically the defense and the Crown meet and resolve, understand each other's side, resolve minor items of disagreement outside of the court. that's the way normal people conduct themselves. You
Reasonable people.
Yeah. So yeah, but the Crown has sent me a letter saying they're not going to talk to me ever outside of the courtroom. And I said to the judge, I said, listen, you guys you guys are under a time frame of Jordan. You have an obligation not to waste the court's resources and times. We have many serious criminals, of rape and murder and whatnot that need to be heard in the courts. And you are putting all those cases in jeopardy, going after me and Tamara and others on these trumped up mischief and politically motivated mischief charges. So I said to the judge, I said, it's within your authority to admonish the Crown's behavior and encourage the Crown to conduct themselves with good faith and have these conversations so we don't waste the court's time. But the judge has so far refused to admonish the Crown or encourage them to be reasonable in their prosecution. They're apparently quite willing to waste court resources and time and potentially put violent criminals on the streets because these mischief charges are more important.
Who knows? Maybe the Crown has become so scary even to judges because how vindictive they are and how much power they have. Even the judge is a little bit worried about getting on the wrong side there. I'm not saying that's what's going on here. The judge could actually be against you as well. But maybe the judge is worried about, not signaling his left turn and getting pulled over and have a problem himself. Amanda, this actually, one of the court hearings, I think one of the first ones, or if not the first one, it was open to the public. You were there, but then I think you got kicked out, and then they stopped the stream for public and kind of went behind closed doors. Am I making that correct?
So my first time with Randy, actually, he was still represented with counsel, and that was his motion to change venue. So that was public. But then when he took Amber off record, that's correct. We went back to the court. It was a judicial pretrial, and I had a hunch that it was supposed to be closed. So I had asked the court reporter before, or the court reporter, or the court clerk. Yeah, the clerk. Prior to the judge coming in the Zoom starting, I said, "Oh, is there a publication ban on this? I'm curious. Like, is this?" And neither one of the two knew. Neither one of the two individuals in the room knew whether or not this JPT had a pub ban, or it was just a ban, just not normally published, because it's usually conducted behind closed doors with counsel. Mm-hmm. But if there's no counsel, I mean, why does it have to be behind closed doors? Why can't Randy opt to have it not behind closed doors? It's up to him, in my opinion, and he's right. In when he was saying earlier with regards to little concessions that these crowns and the judge can make. I mean, the judge has the authority to do whatever she wants. That was Rule 2.01 of how they're supposed to conduct themselves. I had posted a tweet on that. A judge can do anything in the interest of justice. And so when we got there and I think there was over 50 people in the Zoom room. And there was, I think, probably 20 or 30 people in the courtroom with us. And so when it went to start, the Crown right away, he walked in angry. Like he knew there was people in the Zoom, there was people in the room, like you could. And so they cleared the Zoom and everybody was on their best behavior initially. So anyone who says that people were being rude, everyone was fine. Everyone was quiet. People got told to turn their cameras off. That's what they did. But as soon as they were advised that they were going to be clearing the room, that's when the comments started coming out. And of
course,
I'm not supposed to find it funny, and I'm not supposed to, but I'm not licensed, so I thought it was funny. Like it was funny in that, not funny. It was true human responses coming through the Zoom. You were hearing the frustration across Canada, and when you're alone, like Randy was, anybody who's alone would like to hear support. And I'm not saying that he was supporting that at all, because he wasn't. I thought it was appropriate because that's how people felt.
Correct.
And I think we've come to a point in society that we can't talk about how things make us feel. And that's a problem. And if you feel like justice is not justice, you should be able to say it, licensed or not.
Yeah. So
I agree.
Let me add to that. Like the court was open. The Zoom link was public. There was all these people were on the Zoom. All these people were in the court because there had been no indication that there would be a publication ban. It wasn't, as Amanda said, when the Crown, when it came live, I spoke with the judge first, asking for my an accommodation to record things, and there was a couple of little early on items that was being broadcast and that people in the courtroom were witnessing. Then the Crown interjected and said, "Dear Madam Justice, there's a rule here in the rule book that I'm allowed to pull out that says I can ask for a publication ban on the judicial pretrial, and I'm invoking that, but the judge still had the authority at that time to say, no, it's in the public interest that this judicial pretrial be public. But the judge did not invoke that, did not utilize her authority, and just went along with the Crown's assertion that there's a rule here and he's allowed to use it, regardless if it's not in the interest of the public.
My goodness.
And even more, Jason, to add to that, what was interesting, so when they were kicking us all out of the room, Randy asked if I could stay just for note-taking purposes, right? Just to help take notes. And he said she's a paralegal candidate, right? So just to kind of give me a little bit of, I may be an officer of the court one day, so I will keep this confidential. I will follow the rules of, note-taking, etc. And so he says, and they asked, well, is she licensed? No, she's not licensed yet. Well, then she can't stay. Okay. So then he returns the following week with a licensed lawyer who also couldn't stay.
They're making rules on the fly here.
So well, that's just it. They're making them up as they go along. And then, so he brings a friend of the court who is a lawyer in Ontario, who has practiced and is covering other Freedom Convoy trials, Brian Duty. And they
but they still didn't allow him.
They rejected that.
And they're going to bring in they're going to appoint a lawyer.
Right.
Like in what world, like this amicus, we have one sitting right here, right now, today, ready to help out, right? And they kick him out and they're going to find somebody else. So we're talking about these delays. Well, there was somebody there willing to do it. And I think he would be even willing to be the amicus. So I don't understand how the Crown Attorney can go around telling people, this is in the interest of justice, this is in the interest of justice, or any part of the judicial process to say this, and then turn around and delay it even more because the court needs to pick a lawyer when there was one right there. It's.
I think it's clear.
Doing it to Randy, all I have to say is if they're doing it to Randy, I cannot imagine what they are doing to others. And it's high time that people start coming forward. Reach out to me, reach out to you, Jason. And it's about time that we start exposing this, because there was once upon a time where you would think nobody would believe you when you talked about police brutality or you talked about Crown Attorney corruption. You never, most people thought that we were operating in a good country, we're Canada, But
We want to believe that.
we wanted to believe that. You're right. We did. And once you realize that that's not the case, and if they're doing it to Randy, I mean, we're all in trouble. I mean, you can like Randy or not for his politics, okay? I that is not the issue here, okay? I didn't know much about Randy prior to becoming engaged with him with regards to his trial. I met him the first day with David Amber, and I want people to understand that they need to pay attention to Randy, and they need to pay attention to this case. He is spearheading for all of us. He is once again putting his neck out there when nobody else would. And I'm so like, I get messages from people who are like, you know, I like you, but you're siding with Randy. No, I'm not siding with Randy. This has nothing to do with Randy's politics. And I want every Canadian to recognize that this could be you,
Correct,
or your son, or your daughter. And that's my issue. My issue is that I'm an advocate, and I'm raising little advocates. I'm raising girls who speak their mind. I'm raising girls who call out something that seems unjust, even when it comes to me. Even if I do something that makes no logical sense because I've just told them to do it. And if they question it and they can argue it and they can come up with a better reasoning, I'll give it to them. You know?
Yeah.
I do. I give it to them. It's not my way or the highway. It's not how I parent. And unfortunately, I'm from Ottawa, and there's a lot of people who are just do as they're told people here. And it's really not okay for anyone to have a problem with Randy for his politics when we're dealing with something not even related. This is all
Correct,
a matter of him protecting our rights by going on the Hill, being there on January 28th when everybody else failed us, all of them. And for him to be charged 2 months after the fact, he was charged literally because it was January 29th was the incident.
when he
right?
announced he wasn't
Saturday.
running anymore, might have been
What's
the
that?
trigger on that one. When he was announcing he's not running anymore, that might have been the trigger for that.
Well, that's just it, right? Like the 2 months after the fact. So every Canadian needs to be watching this because there's a little bit more opportunity for exposure of what's really going on behind closed doors. And
Right.
that's what's super important. Right now, you and I can talk about Coots until we're blue in the face. We have no idea what's going on. We don't. I mean, you know what's going on. Like Mocha knows what's going on because he's sitting in there, but the rest of Canada doesn't. And that's a problem.
Correct.
A very big problem. And I will say really quickly, sorry, and not to come to the MSN's defense, because I'm not a fan of MSM, but CBC is constantly fighting pub bans for us. CBC they're the ones that are always wanting to be able to produce the articles, right? So they're the ones fighting for us. There was a recent Supreme Court of Canada ruling this summer, and I was trying to find it while I was getting ready, about publication bans. And the victims who wanted the bans lifted won a case this summer in Supreme Court. So there is some leading material. Something about the actual documents, though, that they've submitted is still subject to publication ban. So there is some gray area, of course, because nothing can be easy, right? Jordan, I thought the Jordan ruling. I thought was made the ambiguous reasonable pretty clear. But then the lawyers got their mitts on it, and now it's all been
As they do. Yeah, as they do. Look, I'm going to step in here. CBC, look, you gave them a little bit of clout there. You helped them a bit, but I'm going to just kind of forewarn you there. They are theater professionals. So they're really, really good at making you believe something, including making you believe that they're fighting for you on publication bans. I can tell you that they can fight harder. their arguments could be better, and they can actually win a lot more of those that they're not. Here in Alberta,
interesting. That's a good way to look
here,
at it. Okay.
Here in Alberta, they actually supported the Crown's application for a publication ban on the envelope stuff. I'm sure you may have heard about that in Alberta for the Cootsman. The envelope, it was supported by the CBC lawyer for the publication ban. So they not only pick and choose, not only do they pick and choose which ones that they're going to get behind, I think it's more theater so that people like you can say exactly what you just said there. Hey, look, they're trying. Are they?
Interesting.
Are they? I would put it to you on that one. Randy, I know that your time is up, so I only have a couple more little comments here for you. I think why you're seeing these rule changes and making up the rules as they go along is because you're outsmarting them. You're 100% outsmarting them. They're like, oh, damn, that's right. If he's self-represented, he has to be summoned. He has to be here. We can't have, like, you're outsmarting them, and this is why you're bringing the public with you, too. And this is why the Crown is really, really frustrated with that. Here in Alberta, the Crown doesn't go through the front door anymore. He goes through the back door because, and I'm not joking, it's because he's not worried about the physical anything, because this is Canada. We don't do that. But he is shamed. He's ashamed because he knows what he's doing. Like, his heart knows what he's doing. So he's ashamed. So I think maybe this is why you saw some aggravation from the Crown, pushing hard to get a pub ban in place, calling for rule whatever. The judge just accepts, kicks everybody out. I think that's because you're outsmarting them, Randy. 100%. Last comment I want to make, and then I'll let you finish up there, Randy. Amanda, you and I are lucky because I saw his bail conditions, and I saw the list of people he's not allowed to speak to. There's reporters. There's independent reporters on there. So if we existed back then, I assure you, we'd be on his list because all we do is report. Because he's got some reporters on there, independent reporters on there. So they're trying to silence him. They're trying to stop him from going public with things. They're trying to stop him from gaining public attention and public support. They're failing. And Randy, you're outsmarting them. So keep it up, brother, because I think you're actually going to cause some sort of decision or some sort of case law that's going to help a whole bunch of people going forward.
Well, thank you for the kind words, Jason. And listen, what it is, the adage I would say is they're trying to serve me up a shit sandwich and I'm not eating it. Right?
Yeah.
And that's really what, they're trying to make me eat this garbage, and I'm not going to. But yes, the Crowns are going in the back door. These guys know they're engaged in evil and wrongdoing, and that's why they want my trial to be like the Coots trial, where nobody can see the evil that they're engaged in. Nobody can, and if you can't see, and if you can't collect evidence about the evil, then it becomes very difficult to slay that evil.
Correct. Correct.
And that's why, like, no, I'm not going to play their game. I'm not going to eat their sandwich. I'm going to tell people what's actually going on. And I would just add one other point. Amanda made reference that that this could be you,
Yep.
But I would characterize it just slightly different. And I would say this will be you in this society if we allow this to continue. If we allow our justice system to become a sword and an instrument of evil, then everyone will at some point in time become an enemy of the state. At some point in time, you will have a opinion or view that differs from the government's view, and you will become an enemy. We've seen this play out in history throughout humanity. That whether it was the Inquisition, whether it was Stalin's USSR, whether Pol Pot, it doesn't matter. If you do not defeat evil, it will get you, right?
Correct.
In one way or the other. So this is a battle for everyone. It's a battle for my children, my grandchildren. I am not going to allow them to grow up in a society where they have to be where they are intimidated by the government, where they must live in fear of the government. That's not a country that I will accept as Canada, where we fear government. That's any country where people live in fear of government. That's a totalitarian state. That's an authoritarian state. It is an evil state, and we can't allow Canada to become an evil state.
And I think we're already there a little bit, just to add to that, because like you guys had mentioned, in terms of fundraising for independent reporters, people are terrified to e-transfer money.
Yep.
And
That's
use
part of the
Give,
problem.
Send, Go, or use Stripe or any of those, because they're terrified, but that sending me $20, they might get their bank account frozen.
Yep.
Like that's a problem.
So maybe I'll end off on that. I have to leave, but if you do want to help out, you can go to nomorlockdowns.ca, and you can also donate. If you want to get away and have a weekend or a day of freedom at Scuttlebutt Lodge. You can also, Jason's been to the lodge. We did
with my family and children. It was lovely.
So you can help out in a few different ways if you like, and also by sharing and helping others to become aware and informed of what is going on. And I thank everyone for the great support and help that is out there that people are showing. And I'd also like to say to everyone, have a very, very Merry Christmas.
Yes.
And because I'm going to, all the family will be here for Christmas. So enjoy Christmas. And let's make sure that all our Christmases are joyful and not living in fear. Thank you.
Absolutely. Merry Christmas. Love you, Randy. Last comment I'm going to make, and I'll say goodbye to you. We said it could be us one day. It will be us one day. I'm going to remind you, it is us. There's over 100 people that I haven't spoken about that are already going through this. So some of us are already going through this. So it's not just could be or will be. It is. We're at that point now. Randy, you have yourself a great day. Say hi to the family and enjoy the tractor with the grandchildren. You have a wonderful family. Thank you, Randy.
Bye-bye.
And Amanda, stick around. We can hang out for a bit.
Okay. Bye, Randy.
Bye, Randy. All right. See, that's why we got to get you scoot to the left. So now you're in the middle. Look at it. There you go. Here we go. Wow. What a gentleman. What a man. He is standing up for us. It's difficult for him because he's got to be careful what he says because he's got bail conditions. Even around this conversation, you have to be careful. And look, I think we're at the see no evil, hear no evil, speak no evil. I think that's their plan. They want to blind us. They want to make us deaf. So people like you and I don't